It's easy. New Techno Phantom V Series. Techno, stop at nothing.
Show off your best skin with Nivea Nourishing Cocoa Body Lotion. Now with 5-in-1 Complete Care. The deeply nourishing formula prevents your skin from drying with precious cocoa butter and deep moisture for smooth and healthy looking skin. Step out in confidence with our most complete care from the world's #1 skincare brand.
Present your vision to connect with voters on My Turn on GTV. Election 2024, Ghana wins.
This year, I want to make my candidate with my one. If we the dream or what? You don't know, say every year they easily take the #1 spot, give your favorite candidate. I just don't understand. I think I say easy get procedure where they take choose who go there the top. I said if we take give someone, they take give them a favorite. So then they you sure? You don't be the easy man. Yeah. Okay, what do? Hey, my people. Yeah. Why? You have some more questions? Oh yes, boss man. We want to ask a question about the ballot paper positions.
Respectfully, my lords, civil motion number J5/36/Brassica Pay Limited. K79 Farms. Respectfully, my lords, parties are absent.
Legal representation, please. Legal representation.
Last respectfully. Rosenberg. Adoko. This year, I want to make my candidate with my one. If we the dream or what? You don't know, say every year they easily take the #1 spot, give your favorite candidate. I just don't understand. I think I say easy get procedure where they take choose who go there the top. I said if we take give someone, they take give them a favorite. So then they you sure? You don't be the easy man. Yeah. Okay, what do? Hey, my people. Why? You have some more questions? Oh yes, boss man. We want to ask a question about the ballot paper positions. They will discuss why say if you cut the #1 spot, you take give your favorite. Yes. That's people they do. And you find munya. And you fair. Yes. Oh yes. Don't get what they wanted from the beginning. Huh? Oh, okay. Yes. Do you know that some of them, they even produce adverts, jingles, even before rounds of balloting? Look, in the first balloting, it is used to determine the order in which the one is used to determine the position of the presidential candidates on the ballot paper. Do you understand? Yeah. And then the number that you pick in the final balloting, That is what determines where your presidential candidate will be on the ballot paper.
Okay. You know, be fixed like that.
Not at all. Not at all.
Don't fix it.
Listen, the Electoral Commission does not have a favorite candidate and does not manipulate the processes to the advantage of any candidate. Not at all.
I just don't understand. So this number is
all be lie. All be lie.
except as otherwise provided in this Constitution. Matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of parliament present. Honorable members, we don't have at least half of all the members of parliament present. Consequently, in view of the current circumstances, the fact that there is a question on the composition and constitution of Parliament, and having regard to the public interest and the exigencies of the state of affairs in Parliament, I will proceed to, in accordance with Standing Orders 59, adjourn the House indefinitely. That is sine die. Article 104. The numbers are not sufficient for us to take decisions. And I'll quote Article 104. Article 1041 says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. Honorable members, we don't have at least half of all the members of Parliament present. Consequently, in view of the current circumstances, the fact that there is a question on the composition and constitution of Parliament, and having regard to the public interest and the exigencies of the state of affairs in Parliament, I will proceed to, in accordance with Standing Orders 59, adjourn the House indefinitely. That is sine die. I want to quote Standing Orders 59:1. It says, the Speaker may, in consultation with leadership, suspend a meeting of the House indefinitely or for a period determined by the Speaker, having regard to the public interest and the exigencies of the state of affairs in the country. Honorable members, I have consulted leadership and I am exercising my discretion to decide to suspend the meeting of the House indefinitely. The House is accordingly adjourned sine die. Article 104. The numbers are not sufficient for us to take decisions. And I'll quote Article 104. Article 1041 says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Article 104. The numbers are not sufficient for us to take decisions. And I'll quote Article 104. Article 1041 says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. Honorable members, we don't have at least half of all the members of Parliament present. Consequently, in view of the current circumstances, the fact that there is a question on the composition and constitution of Parliament, and having regard to the public interest and the exigencies of the state of affairs in Parliament, I will proceed to, in accordance with Standing Orders 59, adjourn the House indefinitely. That is sine die. I want to quote Standing Orders 59:1. It says, the Speaker may, in consultation with leadership, suspend a meeting of the House indefinitely or for a period determined by the Speaker, having regard to the public interest and the exigencies of the state of affairs in the country. Honorable members, I have consulted leadership and I am exercising my discretion to decide to suspend the meeting of the House indefinitely. The House is accordingly adjourned sine die.
The case of National Investment Bank, number 1. There's a Standard Offshore Trust Company, number 1, report at page 7, provisions in the rules we urge the court to follow arises from originating proceedings like so several. Secondly, the rules are mandatory, and the courts and this same court says that when they are mandatory, they will be enforced. And finally, where the proceedings are originating in nature, that even if it were curable, which it is not, to entertain, the court lacked jurisdiction to entertain the matter, is to determine whether or not the seat of a member of Parliament is vacant. That matter belongs exclusively to the jurisdiction of the High Court, with the membership of a person in Parliament. That belongs in the realm of the High Court, not this court. But I want to emphasize the point that, admittedly, in every instance, they will regarding whether or not constitutional provisions. It won't make it a dispute properly invoking the original jurisdiction of the court. So whether or not there will be matter, and in this matter, have become vacant. Those seats will be deemed vacant. But to go into and find out whether the facts establishing those circumstances in Article 97 have arisen or not. That the court had no jurisdiction, and that one training of the Speaker relates to was not before the court. The first defendant's ruling, which is on any judicial, is the strike expression. Says execute the judgments of courts. The Speaker's ruling is not executed. For arises from the plain applications. High Court. Here, there is sub-rule 3, or when having to read the sub-rule, despite that the delay caused, we are 40. He got a motion for bringing an opportunity on that Monday. However short of that, we fed the rules of natural justice within an hour, directed and practice. Barclays Bank in Ghana, 1998.
Constitution with authority ground 22 of our justification and 22 of our affidavit. Potential irreparable and this action was to commence in the ordinary way. Lord 8 of CI 47. Yes, of CI 47. Lord, the point we seek to make is that 8, very well, Lord, I'm grateful. 1, 8, very well.
You don't have CI 47 there? Then kindly move on. Telling you under 25 rule 1, your time is up.
Of agency dispatch response. Any mischief, the fact that we now and its dissolution. My Lord is the only court. So regardless of the fact that it's not stated in the rules of the Supreme Court, my Lord, nothing and nothing raised, my Lord, Constitution to make appropriate giving effect or enabling effect to a declaration. We're not given the opportunity, the rules of natural justice made by Lord Amrandi.
We can only limit us. If you don't mind.
Very well. Okay. That Lord all said and done, has not breached any procedure of any substantive law, but granted without Rule 79 and Order 81. No, Rule 79 of CI 60. It's my case, I'm grateful. And my Lord, whether executable or non-executable, it's not far-fetched on the scope.
Listen, before it's not about the part. To the laws governing the jurisdiction of the court. The court challenge the decision of the court violates the 3+1. 2, and I quote, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Especially the instant application 6 and order setting aside the process and proceedings of the court and vacating the law of the court. Respectfully, the decision in question, respectfully, Article 183+1, the review, 133, I'm sorry, 133, the review, you seek a review or review. It doesn't invoke to the laws governing the jurisdiction of the court. Especially Article 134 of a decision of a single justice Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed in the Constitution, and this is not, especially the second point we make, with the defendant constitutes a basis for a setting aside that, I'll just be quick about it. The court has no jurisdiction to entertain the suit before the court. The court has no jurisdiction to stay execution of a ruling of the Speaker of the Parliament of Ghana. Respectively, paragraphs 12 also read paragraph 12. So the words used in that have no disputed meaning, and no basis exists in the processes filed for assuming that there's dispute. Then paragraph 13 says the words used in the provisions of Article 97 clause 1 should be elected to Parliament to join a political party or to become an independent member of Parliament, or where a member of Parliament elected as an independent member of Parliament joins a political party, they shall 29 to 32 of the affidavit in support. And again, they constitute substantive defenses to the action.
Honorable Attorney General, you know you have 10 minutes.
The 19th Constitution of the Republic of Ghana government is expected to overstep its bounds. The same is repeated in other parts of the affidavit. So the point I make respectfully is that does not invoke the decision of the court, because in the view, the filing of an application to set aside the rates on that basis. Indeed, the grounds for such a contention, that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General filed issues for determination in this matter, and those are issues raised in for determination by the court. Respectfully, indeed, the application completely misunderstands and misconceives the Supreme Court's original jurisdiction. And I made the point that, indeed, the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, Counsel for Defense Defendant, on which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a similar case in it, and total trouble case for a controversy. But indeed, my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. That would be the basis for lawless conduct. And this honorable court owes a duty not to encourage him. I'm fortified in this proposition by the locus classicus on the matter to follow an Attorney General reported in 1980 Ghana Law Report at page 637. And where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the invocation of the court's original jurisdiction. Respectfully, the points I make today are not points being sought to be established today. They are matters that have been long established since 5-0 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to vetting. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon an interpretation of the Constitution. Clause 1 of Article 118. The court has reason to entertain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectfully, the court were defendants, and therefore the writ which mentioned some members of parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of parliament and have just stated a question for determination by the court whether upon a true and proper interpretation of Article 97, Clause 1, paragraphs J and H of the Constitution, and the court would have been seized with jurisdiction. First defendant makes reference to an alleged denial of the right to a hearing, auditory pattern, or even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court entertaining an application of the right to a hearing. Then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission, respectfully, I would respond to the contention made by my learned friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I do not seek to even go into the merits of the understanding. But the point must be made that constitutional public, right,
of this nation.
Right.
It is important to address the facts behind that matter.
Right.
A circular in 2021 to regulate service on members of, to discuss. So I reviewed what my predecessor did and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Lady, respectfully, that I'm just putting forward a circular of this nature. It's the proper interpretation of the Constitution. And indeed, as held in before Nigeria, even if, assuming with all respect, it's immaterial.
A circular.
The circular, written such a circular, it is immaterial for me. It is a constitutional process which was subsequently pronounced upon as unconstitutional by the court. Could not have waived any right whatsoever. Because there's no such thing as Articles 117 and 118. All it says is that civil or criminal process in relation to the Speaker returning from any proceedings of Parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Alexandra, can, or any citizen of the land, having invoked the decision of the Supreme Court, can serve the process on a member of Parliament. That's what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that
that is a real point of law. So but he's exceeding.
Sit down.
Yes, the point of law I made it because the application is because 2 clause 1 and 130 clause 1 extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual in the Constitution. And the Constitution spells out the content and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office. The Supreme Court in Tufo Natenjera and further fortified by J.H. Mensah and Atenjua, reported in 1996 Supreme Court of Ghana law report, stated clearly that in Ghana, there's even no such thing as a political question. The contention by Malay Fair Council for First Defendants that the administrative decision of a person or a service survey that the application before you is totally offensive to all rules and procedure of this honorable court is unknown to the laws of Ghana and must be dismissed.
Just some short points of law, especially that they were made on points of law, and I'll be very short. First point is the simple answer. Since the day an order is a nullity, you can come by any procedure to set it aside. It remains the law following from that. He likes to cite cases of vintage. He says over 40 years. You calculate when we say they were here when they say there is a misconception and a misunderstanding. They have remained here. Mm-hmm. And this is the clearest example of a misconception and misunderstanding. First rule. 2, all due respect, some matters, and that should, I'm mixing, yes.
From submitting a defense, this court gives an order and you wish for it to be vacated, reversed, varied, discharged. The onus is on you to bring an application under the review jurisdiction of the court, and not an application such as...
The principle of civil procedure is that the rules of review aside, this court delivers judgment according to 3 main yardsticks: statute, law, and set aside. And I'm saying way back from up to date, that remains the law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court in my defense, and I'm taking it in limine, another elementary grounds. Now let me just deal with the Article 2.1 point. Tandrously said the court to determine a membership of Parliament. They also come under Article 2.1, but the court has always said that yes, if there's anything about the fact that if a matter is within...
Your 1 minute is up.
Well, there are other cases. More recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And as for the circular, my Lord, the Chief Justice must have had reason to issue it, and if he knows what to do, he should come and declare it unconstitutional. That's the point.
You are done.
I'm done. But if my time was happening.
The case is stood down for the court to rule.
GTV. The court proceedings here at the Supreme Court, and we all know the issues at stake since 9 a.m. This whole matter is about the Supreme Court's decision to stay proceedings in Parliament with regards to the 4 vacant that has happened so far. Currently, we are being told the court has stayed its sitting to deliberate on what submissions they received so far all morning. But my 2 colleagues here would help me to understand what happened in the court further. But before I do that, I'd like to go to my colleague Augustus to probably update us how this whole case started from Parliament, and today we are here at the Supreme Court for interpretations of the law. Augustus Akwe, I mean, for a layman out there, they only know that whenever there's a case in Parliament, you hear the views of the majority and the minority. But today, we are all at a loss as to whether who is the majority and who is the minority. Tell us how this case started.
Now, when it comes to Parliament, they deal basically with numbers, because there is one candidate, because opponent member a number up, yes, and so the 2020 election, he was then a sitting NPP, so he came on the ticket of the NPP in the 7th Parliament, but he filed as an independent. This man was sponsored by us to enter your Parliament. He has ceased to exist with us. And so based on that, then Speaker Professor Mike Eronoke declared his seat vacant. And the NP, Mwakwesi actually stayed outside sittings of Parliament till then former minority leader and MP for Tamale South, Haruna Idrisu, leader of the NPP caucus, Alexandra Afenyo-Markkin, that he intended to pray the Speaker to declare 4 seats vacant, and to whom Kojo Asante had all filed as independent candidates, though they were NPP sitting members of Parliament. Then there is Amenfi was planning to contest as an independent candidate, and so that was the Mr. Afenyo-Markkin also noted that he intends to go to the Supreme Court, would mean he has to vacate the seat because the Constitution is not clear on that, and the Supreme Court is the interpreter of the Constitution. So that is what but
probably based on the precedents that had happened
to the Speaker at that time in 2020 to declare the seat vacant. But in this case, he was the leader of the caucus, and none of the members on his side who were going for independent had told him that they intended to go. They intended to leave the caucus, and so for him, whilst this deliberation was going on, the leader of the NDC caucus, Dr. Kesalato Forsen, raised a statement on the floor to note that these were the pending issue. The Speaker, he was praying the Speaker to declare those orders, and it's also governed by precedents. Yes. And so sometimes issues might not be in plain ink on paper, but because there might have been an incident where a former speaker had ruled on the matter, they would be guided by that precedent. And so Dr. Atuforsen was fortified by that precedent in 2020, after which court's interpretation. Now, already remember that he had filed a notice to the court, or he had prayed the court to look at the substantive matter of interpreting. And since the new matter had arisen for the court to stay execution of the sentence was to be heard. So that is what served Parliament, i.e. the legal office of Parliament, the ruling it had made that the Speaker should stay that execution. After the court served that ruling, the Speaker has also had made a counter application to the court that the court doesn't have jurisdiction in such a matter. So that is what we are listening to this morning. Earlier on, the counter suit the Speaker had made a court, as in the court not having the locus to deal with that matter. And so that preliminary objection was also
to these matters, and she's our court correspondent. I mean, we've all been monitoring proceedings on air since morning, and we've seen Thaddeus Sorry on his feet most of the time trying to make a case or defend a case. Explain to us, as a layman, what has happened in Parliament, in the courts today.
Thank you, Sarah. So basically, this is what happened in court today. Today's hearing or sitting is to hear the matter that the Speaker, Honourable Speaker of Parliament, has brought before the court for the court to rescind or revise. My colleague explained earlier. So when the case was called earlier in the morning, like my colleague said, there were some objections raised by the AG and also by the lawyer for Afenyo-Markkin. Sorry if I don't put the Speaker of Parliament attempted some accusation of the courts of the objections were to be looked.
Substantive case has not
stood down the matter earlier. Colleague almost briefed us about earlier that the lawyer for the Speaker of Parliament, Thaddeus Sorry, argued or submitted their case about why the argument that one, the court didn't have jurisdiction to hear that matter because the Parliament was way outside of the court's jurisdiction, and then also because when the decision on 18th October was made, it was made ex parte. That decision or the application was filed ex parte and was heard ex parte, and so the Speaker was thinking or is thinking that it's breached his natural justice as a person to also be heard or to be put on notice about the application. And since the court didn't do that, then its entire decision is an error of the law, and so it must be rescinded. It must be rescinded, basically. So we came back, and the lawyer for Afenyo-Markkin, he opposed the application by the Speaker of Parliament for the court to rescind on this matter because there was nothing.
It was like a base.
There was no error. Argument. Yes. Basically, that's what they said. And the AG also made similar arguments in court earlier. And after the court stood the case down and has gone into chambers to deliberate over matters and then come. We bring all that to our listeners.
But we observed that whilst sitting was going on, or whilst the court proceedings was going on, we observed the judges retreating most of the time. Sometimes we thought they were going to adjourn the case and all that. But explain to us what would necessitate the panel of judges to retreat and go back and come back and sit on the case.
Sarah, I'm sure you know I'm not a lawyer.
Yes.
But I think let me hazard a guess or an answer to it. I think that's the procedure here in court. They hear the case, and if they think they can't make a decision on it, then they retrieve to chambers, work on it. So basically
that's happened since morning. The substantive case as to whether the Supreme Court would rescind its decision as to staying the Speaker's decision to declare those 4 seats vacant has not even been heard, or it's not even started. What the argument has been so far since morning is the tone or the language with which the Speaker's countersuit or case was made to the court. And so as we heard or as we saw early on, the panel of judges have retreated to their chambers to decide on whether the case will be heard, the substantive case will be heard or adjourned today. So I'll be handing over to the studios, and we'll come back to update you as and when we have new updates from the courts.
high crime under this constitution, and shall, in the case of the president or the vice president, constitute a ground for removal from office under this constitution. 5. A person convicted of a high crime under clause 4 of this article shall A, be liable to imprisonment not exceeding 10 years without the option of a fine, and B, not be eligible for election or for appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment. From the above, it can be seen from the very first page of the 1992 Constitution that the most fundamental and hallowed right of every Ghanaian that the 1992 Constitution gives and jealously guards is that when anyone, including the president and vice president, is embarking on an act, on any act that violates any provision of the Constitution, or if anyone is of the considered opinion that any law or rule enacted by any legislative body breaches the Constitution, that person can run to the Supreme Court for enforcement of the Constitution. That person does not even need to be directly affected by that act or law. This Supreme Court regularly exercises this original and exclusive jurisdiction for citizens of this country. Second, Article 130 provides, 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction and in A, all matters relating to the enforcement or interpretation of this Constitution. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or persons by law or under this Constitution. Where an issue that relates to matter or question referred to in clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with a correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of Parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of Parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether as a member of Parliament or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed, by reason of the meaning of Article 97(1)(g), to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in this suit. On the contrary, we find that nothing can be clearer in the record from Parliament that was brought to this court and considered before this court's ruling of 18th October 2024 that this was an executable ruling. The Speaker's ruling is headed, quote, "Formal communication by the Speaker." It set out the background of issues he was considering and covers 10 pages of evaluation of law and fact. He concluded by declaring that, quote, "The MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they do not believe in and have no loyalty for in this House any longer. The House is accordingly informed," unquote. These are words that affect the rights of these MPs to remain in Parliament and the rights of their constituents to their representation. Thus, if a controversy is raised to the propriety of the interpretation of Article 97(1)(g) that led to this conclusion, then this court is rightly sized with jurisdiction to provide a hearing to the plaintiff. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next parliament and not while sitting in the 8th parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97.1. A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if he is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. Or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker. Or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2. Notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex parte Zaneto Rollins, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes on the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024 in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, The Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker, the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay as enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 1(8) of the High Court Civil Procedure Rules 2004 CI 47 that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Lord, we are extremely grateful.
Ask the court, please, Ismail.
So, Mr.
Grateful.
So, Mr. Sorry, will you be filing anything, or should we hear without you?
Oh no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the Speaker on Monday, so he has 7 days. I'll speak with him, draw his attention to the court's ruling, and then.
So it was served on him on the order was served on him on Monday.
Last Monday.
Monday was 29th?
No, last Monday is the 20th.
Yeah. Monday, just about 2 weeks ago.
No, wait.
No,
on the 20th. It was served on the 20th.
On the 20th?
No,
and
21st.
Today is the
21st. It was 21st.
So he's gone past the 7 days?
No, but if he's served with the order on that specific date, telling him to file within 7 days, it takes effect from the date of service. That is my understanding.
So he was supposed to file by 28th?
No, by the rules of the court, where the time limited for doing something is 7 days or less, weekends.
So he was supposed to file by when?
If we take out. No. Today.
Today?
Yes.
This suit is adjourned to Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare.
Very well.
Yes,
I take it that's really in your
so if I would plead that because this, look at the time that we are closing and the fact that we've done some work, filing it by Friday is not it's not possible. I also need to still go and take instructions. So maybe next week is fair. Today is Wednesday. All right. Next week. At least if I'll take 7 days to file the two.
No, do not count your 7 days from today. Your 7 days started running from 21st. You cannot make your own rules.
I'm just praying the court. I'm not making rules. I'm just praying the court.
It's okay.
So you will file by what date?
By Monday.
By Monday. No.
My lady, respectfully. Sorry. Yes, but respectfully, there are 2 points that arise out of my reference and brief submission to the court. And I made them. One, it is a matter for the interpretation of the Constitution. Respectfully, as I earlier on submitted, in the matter involving the interpretation of the Constitution, there's even no such party as a party who has an interest in the matter, apart from the entire state. Respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. So my submission is that
in the Constitution. In the Constitution,
yes.
In all constitutional actions, the Attorney General is required
to be the defendant.
To be a party.
Yes, to be a party. And respectfully, the point I make is that indeed the reluctance, with all respect, of the first defendant.
Can we get to know the objective?
Right. That first and foremost, if the first defendant is unwilling, with all respect, to file processes to enable the court complete the case by Friday, my submission is that the first defendant is not even a proper party to the proceedings before the court, and his absence will not derogate from the court's ability to proceed with the hearing of the matter, because he, the first defendant, has no personal interest in the proceedings before the court. Indeed, it is even improper for the first defendant to have been joined to the action. The proper defendant should have been only the Attorney General. The second submission I make is actually linked with the first. Especially if a party who is a public officer is joined to a constitutional action involving the Attorney General, that party, if the court allows it, will have to procure services lawfully. My submission is that every counsel for the first defendant has
just coming from the Supreme Court, where the justices are dealing with the issue relating to the vacant seats in Parliament. Well, the sitting has been adjourned and some clarity has been established as to when the court will sit again. Well, let's turn attention to the big event today. It's the final of the National Science and Maths Quiz. Kofi Ajay is in studio with me, and this is the big moment. We're going to take a close look at the performance of the teams in this contest so far. Take a proper look at their history in the National Science and Maths Quiz and give you a little idea of who is likely to come top today. It's KSTS, Kita SHTS, Infantapim, and of course, St. Augustine's College. Kofi Ajay, the students are really buzzing. Excitement is high, and everybody is waiting with bated breath to see who will clinch the title. What have you got for us today?
Well, I mean, there's this theory that we've been running since 2017, and this theory, or what we call the hypothesis, always actually pans out in the finals. The hypothesis is that the school that goes to the final with the highest average score always goes ahead to win the contest.
The school that goes to the final with the highest average score,
from the 1-8 to the semifinals, goes ahead to win the the trophy. It started 2019. Let's see what happened. St. Augustine's College, the same school that is actually in this year's final, went to that final with the highest average, 56, followed by Presec, and then also there is Pesco, 52.3. What happens is that in the final, the grand final, what you see is that the same arrangement. Just look at it. St. Augustine, we have Presec and then also Pesco, the same arrangement in 2019. Let's go to
and to break this down a bit more closely is that what you're showing us here is that the team that had the highest score from the quarterfinals to the semifinals since at least 2019 have gone on to win it.
Yeah, good. I mean, the school that has the highest always goes ahead to win. The same thing.
So in 2019, St. Augustine's won it because they had the highest score from the quarterfinals. 2020,
same story. Started with Presbyterian boys. They had the highest 58.8.
Article 104. The numbers are not sufficient for us to take decisions. And I'll quote Article 104. Article 1041 says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. Honourable members, we don't have at least half of all the members of parliament present. Consequently, in view of the current circumstances, the fact that there is a question on the composition and constitution of Parliament, and having regard to the public interest and the exigencies of the state of affairs in Parliament, I will proceed to, in accordance with Standing Orders 59, adjourn the House indefinitely. That is sine die. I want to quote Standing Orders 59:1. It says, the Speaker may, in consultation with leadership, suspend a meeting of the House indefinitely or for a period determined by the Speaker, having regard to the public interest and the exigencies of the state of affairs in the country. Honorable members, I have consulted leadership and I am exercising my discretion to decide to suspend the meeting of the House indefinitely. The House is accordingly adjourned sine die.
We are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right, and indeed the court has just done
Decisions on the substantive suit to be taken by the substantive panel, which will sit in the next few minutes. The court will rise.